Why most favored? Bakit nga ba ito tinawag na most favored? Diba? Parang hindi siya magandang pakinggan. Most favored nation. This sounds like a contradiction, right? It suggests a special treatment, but in the WTO or the World Trade Organization, it actually means non-discrimination. For WTO, it means treating virtually everyone equally. So this is what happens. Each member treats all the other members equally as most favored. If a country improves the benefits that it gives to one trading partner, it has to give the same best treatment to all others WTO members so that they all remain most favored. These are also the principles under the international trade law. And the trading system should be, first, without discrimination. A country should not discriminate between its trading partners, giving them equally most favored nation or MFN status. And it should not discriminate between its own and foreign products, services, or nationals. They should have national treatment. Second, we have freer. Under freer, barriers coming down through negotiation. So, depende na yan sa pag-uusap ng dalawang trading partner. And third, we have predictable. Predictable, foreign companies, investors, and governments should be confident that trade barriers, including the tariffs and non-tariffs, and market opening commitments are bound in the WTO or the World Trade Organization. Next, we have more competitive. Discouraging unfair practices such as export subsidies and dumping products at below cost to gain market share. And lastly, we have more beneficial for less developed countries, giving them more time to adjust, greater flexibility, and the special privileges. So these are also the principles under the international trade law. And this trading system should have without discrimination, fair, predictable, more competitive, and lastly, more beneficial for less developed countries. Trade and intellectual property. Trade-related aspects of intellectual property rights agreement required signatory nations to raise intellectual property rights. It is also known as intellectual monopoly privileges. This arguably has had a negative impact on access to essential medicines in some nations such as less developed countries, as the local economy is not as capable of producing more technical products such as pharmaceuticals. Understanding the trade and intellectual property. The agreement is legal recognition of the significance of links between intellectual property and trade. Intellectual property refers to creations of the mind. This creation can take many different forms, such as artistic expressions, signs, symbols, and names used in commerce, designs, and inventions. How trade related to intellectual property rights. Intellectual property rights are legal rights that provide creators protection for original works, inventions, or the appearance of products, artistic works, scientific developments, and so on. It is granted by government to encourage innovation and creative output by ensuring the creators reap the benefits of their inventions or works. Since 1988, Congress has included intellectual property rights as principal trade negotiating objective for trade agreements and trade promotion authority. 4 types of intellectual property rights. We have copyrights, patents, trademarks, and trade secrets. If you are a business owner or trying to become a business owner, you should familiarize yourself with the 4 types of intellectual property, otherwise known as IP. We speak with entrepreneurs who don't know where to begin when it comes to protecting their ideas and inventions. They need this information frequently, so we decided to create a quick and easy guide to educate them. First, we have copyrights. What is copyrights? According to our research, copyrights is a form of protection provided by the laws of United States to the authors of original works of authorship. Copyrights protects writing, features, music, art, and other form of intellectual works. What this means to you is that if you wrote something or created a piece of work that you don't want people to reuse without your permission. Now, if people want to use or reuse or repurpose your work, they must first contact you to use it, attribute you as the owner, and use it for purposes you deem appropriate. There is an exception to this rule, and that is fair use. If someone wants to use a portion of your work for educational, parody, commenting, or news purpose, so they can. We have patents. What are patents? According to the United States Patent Office, a patent for an invention is the grant of a property right to the inventor. Generally, this patent lasts for 20 years from when the inventor attempts to patent their invention by filing with the US government. The list of things that can be patented is fairly lengthy and open to interpretation, but it covers anyone who invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof may obtain a patent. For a business owner or an inventor, this means that if you found a new way to make something or discovered a new product you'd like to take to the market, you would want to first patent the idea so no one can take the idea and claim it as their own. For instance, if you have a revolutionary water bottle that you feel would benefit the masses, you should protect this intellectual property by filing with Patent Office that the idea is a unique and your own. If the government agrees that the idea is your own, unique, and it is useful, and you will be awarded a patent to protect your right to the concept. This then gives you the ability to produce the concept, sell it, or bring it to the concept to investors without worrying about them stealing your ideas. However, a word of caution: if you share your patented ideas, there is a risk that others will reverse engineer your concept. Reverse engineering is when competitors take apart an object or idea to understand how it functions with the goal of enhancing or modifying the object in order to replicate it. Making enough variations to the original concept can result in a unique idea that your competitors can then patent as their own idea. Companies can avoid compensating you for your patent idea and claim this new version of your idea as their own. This frequently happens in the technology industry between companies like Samsung and Apple. So here is the takeaway. Protect your ideas and invention with patents before sharing them with the world. Trade secrets. What are trade secrets? Generally, any piece of confidential corporate information which gives any business a competitive advantage can be discovered or considered as a trade secret. For instance, Coca-Cola's secret formula could be considered as a trade secret. Now, if I created a soda company and produced identical soda to Coca-Cola, this would be an infringement of Coke's trade secret. This is a general example, but trade secrets can even defined as distribution methods, sales methods, consumer information, ad campaigns and strategies, list of vendors, list of clients, and production processes. Generally, trade secrets are leaked through corporate breach of contract or something as simple as leaving your prototype iPhone at a bar. A trade secret must be designated as such before it is leaked. One cannot simply say, "I have a secret." Use non-disclosure agreements and designate information as trade secrets in contracts when dealing with partner companies and employees. There are other ways to designate information as a trade secret. To learn more, you should contact Spence PC. As takeaway, protect your trade secrets, keep employees on a need-to-know basis. If you're letting an employee go, make sure they don't have access to your client files after they have been terminated. To learn more about protecting your company and your trade secrets from corporate espionage, check out this